From the National Constitution Center in Philadelphia, this is We the People. I'm Julie Silverbrook, Vice President of Civic Education. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. On February 20th, the Supreme Court ruled that the International Emergency Economic Powers Act, known as IEEPA, does not authorize President Trump's sweeping tariffs. In a pair of consolidated cases, Learning Resources, Inc. v. Trump and VOS Selections v. Trump, the court held that the statute does not grant the president the power to impose tariffs of this scale under a declaration of foreign or economic emergency. In this episode, we explore what the court held, why the justices disagreed about the reasoning, and what this decision might tell us about the future of presidential emergency power. To help us explore these questions are two leading court watchers and constitutional experts. Zachary Shemtob is the executive editor of SCOTUSblog. Zach has written extensively on the Supreme Court and its jurisprudence for both academic journals and the popular press. Prior to joining SCOTUSblog, he practiced law, clerked for federal judges on the U.S. Court of Appeals for the Second Circuit and the U.S. District Court for the Southern District of New York, and was a professor of criminology. Zach, it is wonderful to welcome you to the We the People podcast.
Glad to be here.
And Ilya Somin is professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. Together with the Liberty Justice Center and others, Ilya was co-counsel for respondents in VOS Selections v. Trump, one of the tariff cases decided by the court. Ilya, it is wonderful to welcome you back to We the People.
Thank you for having me.
Zach, let's start with you. Before we really dig in on the doctrine, help ground us in the facts of the case. What exactly did President Trump do under IEEPA, and what did the court ultimately hold?
So IEEPA, to put it simply, was passed in 1977. There was a predecessor statute to it to deal with unusual and extraordinary threats. A provision of the law provides that when there's a national emergency, the president may, among many other things, regulate ... importation of property in which any foreign country or a national thereof has any interest. Essentially, using this provision, the president last year, over a period of time, issued a series of executive orders imposing tariffs. One set of tariffs was known as the trafficking tariffs, and this dealt with products from China, Canada, and Mexico, and the idea that if they limited fentanyl in particular, if these were limited, then the tariffs would go away. The other tariffs were known as the reciprocal tariffs, and this was an initial tariff of 10% on imports from almost all countries, and then even higher tariffs on products from dozens of countries. The tariffs, as many of us know, ebbed and flowed and oscillated over time, and it was a very confusing patchwork. But essentially, using IEEPA, the president imposed these tariffs. Then, in a splintered decision last Friday, the Supreme Court agreed with the challengers, or some of the challengers, that IEEPA did not give the president the power to impose the tariffs. There was, according to the majority opinion, which was written by Chief Justice John Roberts, quoting him, he said, based on two words separated by 16 others in IEEPA, those words being regulate and importation, the president asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words, according to Roberts, cannot bear such weight. And on that basis, and major questions doctrine, which we're going to talk about at length, no doubt, the court ultimately struck the tariffs as imposed under IEEPA.
Ilya, I want to take a step back because the major questions doctrine is a major question that a lot of people have. This may be the first time that many people in the public are hearing about it. What is the major questions doctrine, and why did some members of the court believe it applied here?
Sure. 3 to be exact, concluded that it does. So the major question doctrine is a rule that says that when the executive claims that Congress has delegated to it sweeping power over some major social or economic issue, that at the very least, they have to show that Congress spoke clearly on the subject. There's a clear delegation in the text of the statute. And over the years, they have struck down a number of presidential initiatives based on this, most notably President Biden's massive student loan forgiveness plan. Why does the major questions doctrine apply here? Well, first, this is a very obvious major question. In fact, it's the biggest major question any of us have ever seen, unless maybe you were alive for the Schechter Poultry case back in 1935. And so here we have the tariffs amounting to the biggest trade war since the Great Depression. It would have imposed over a 10-year period something like $1.7 trillion in new taxes on Americans. It would have done grave damage to the economy. It already disrupted trading relationships and alliances with countries around the world. So it's unquestionably major. And it's also unquestionable that at the very least, it's far from clear that these tariffs were authorized by the statute. The statute does not even mention the word tariff or any synonym like duties or imposts. So it's at the very least not clear that these tariffs were authorized. Though, of course, we contended, and the court ultimately disagreed with us, that it is actually clear that the tariffs were not authorized by the statute. But to the extent that there is doubt, the major questions doctrine applies and should apply. And three of the justices in the majority, the three conservative justices, John Roberts, Neil Gorsuch, and Amy Coney Barrett, they agreed that major questions doctrine applied and that it dictated a ruling in our favor, though the ordinary meaning of the words of the statute also led to that conclusion as well.
The court emphasized that no president had used IEEPA to impose tariffs in nearly 50 years. Why does historical practice matter in a separation of powers case?
It doesn't always matter, but I think it matters here for a couple reasons. One is the extent to which an action is unprecedented matters for the major questions doctrine. Also, it matters just for ordinary statutory interpretation in that if a statute has been around for a long time, but it has never been used for this particular purpose, that's some indication that at the time it was enacted and thereafter it was not understood in a way that would include this particular power, particularly this vast sweeping power to impose any tariffs the president might want against any nation for any reason. That's something that if it was there, it seems like it would have been discovered before Trump's second term.
Zach, I want to focus on some of the concurrences that are in the mix for this 6-3 opinion. In their concurrences, Justice Gorsuch describes the major questions doctrine as a structural safeguard of Congress's Article I authority, while Justice Barrett treats it more as a contextual tool of statutory interpretation. What do you think the significance is of that divide for future cases?
So right now, the significance is more philosophical than practical, but it's a really interesting significance because it goes to their understanding of jurisprudence and the Constitution in general. Gorsuch is taking a very strong, muscular approach, a judicial flex, in the sense that he believes the major questions doctrine is predicated on the separation of powers, the idea that Congress has certain powers, and if it gives those powers or delegates its powers to the executive branch, if it doesn't say so, then that is deeply problematic to the whole structure of the Constitution, which plays into a larger doctrine ultimately called the non-delegation doctrine about what it can and cannot delegate. So for him, this is a structural, foundational issue. In Justice Barrett's view, it's a little different. It is a common sense, I'd say, linguistic viewpoint, or the idea that when we tell someone to do something of great importance, it's not to be implied that, in fact, it should be explicit if it's going to be done at all. So the idea is, again, if Congress had told the president, had given the president these powers, then it would have ordinarily done so explicitly. And if it didn't do so, then as a matter of common sense, as a matter of linguistic usage, it didn't enable the president to have these powers. So it's much less of a structural issue and much more of a, well, how do we use language? What's common sense here? And so this is a fundamental disagreement between the two. Again, how that's going to play out in concrete cases is unclear, but they are very much, going at each other, trying to differentiate their different views of this very important and influential doctrine.
Ilya, I would love for you to weigh in on this as well. There's some prognostication that I'm requesting from both of you here, but whose view do you think will prevail? Justice Gorsuch or Justice Barrett, or neither?
So I would say two things about this. One is the major questions doctrine has been around for some years, and the other four justices who use it regularly have shown little inclination to weigh in on which of these two theoretical bases for the doctrine is correct. And they may well continue to not weigh in because they may think that what matters is that the doctrine is there and that it's applicable. And in concrete cases, with possible very rare exceptions, it will matter very little whether the doctrine is justified based on structural considerations or whether it's justified based on linguistic or common sense considerations. They will both point to the same conclusion in almost every case, if not every case. I will also say that these two rationales are not mutually exclusive, and I, in fact, think they're both right. It can be simultaneously true that the major questions doctrine is justified by ordinary usage and common sense and linguistic conventions, and also that it's justified as a kind of structural stand-in for the non-delegation doctrine, that if the court is not willing to have a stronger, robust non-delegation doctrine, which simply says Congress cannot delegate sufficiently broad sweeping powers to the president when it goes too far, that at the very least, we have what is known as a clear statement rule, that Congress must be clear when it does that, so presidents could not twist sort of vague and unclear standards into vast sweeping delegations of power that no one has thought of before. So I actually think they're both right, even though the two of them clearly do not believe that, and they each think that like they're right and the other person is wrong.
I agree with Ilya. I think where we're heading is kind of this hybrid of both are right. I am, as someone who's kind of the other side, who's a bit skeptical of the major questions doctrine. I think, though, that likely we're heading to a place where it's going to be viewed as encompassing both, but is unlikely to actually make a difference at the end of the day on the ground. I don't think, though, that Gorsuch's more robust view is going to ultimately be embraced by a majority or close to a majority of the court.
And this leads me to my next question, because, of course, Justices Kagan, Sotomayor, and Jackson, while they agree with the outcome, they declined to rely on the major questions doctrine, which I think tells us something about how settled the court's understanding of the doctrine really is. Why did they not rely on the major questions doctrine?
Yeah. So I think for two reasons. One is they said, and actually the other three justice majority seem to agree with this, that you don't need the major questions doctrine here. You can just rely on the words of the statute and their natural meaning, which does not include the power to impose tariffs or any other kind of taxes, and there's relevant history. And they also, by the way, importantly agree with the other three justices that the sweeping nature of the power that the president claimed is relevant here, but they say that's relevant just under ordinary rules of statutory interpretation. So one reason is they just think it's not necessary. And I agree that it's not necessary, though I also think that it's perfectly legitimate for the court to have multiple bases for its decision, and both bases can be relevant precedent. And there are many cases where the court says we have 2 or 3 or 4 reasons why this outcome is justified, and all of them can be used simultaneously. The second reason for why the 3 liberal justices didn't use the major questions doctrine here is frankly that they don't like the major questions doctrine, and Kagan in particular has made that clear in previous opinions. And I think she and possibly the others, they worry that that the major questions doctrine will inhibit useful presidential policy making or will inhibit their autonomy too much. I see that as a feature rather than a bug, but obviously, they think otherwise.
Yeah, I think Kagan in particular is thinking strategically. The idea that a president on the other side may end up, as Ilya said, being hamstrung by this doctrine when it's needed to impose some important, whether it's on the other economic or health program. And so they don't want to empower the president to be able to do this. I would note that Jackson wrote a concurrence as well, and that was about legislative history. Right now, we have a court which is very textually driven. They're all, for the most part, good textualists, including Kagan, who, in a certain extent, in the mold of Scalia, and the idea that, the text resolves these issues. And Jackson actually pushes against that, joined by no one, saying that actually we can also look to legislative history, the reasons and objectives of this law, rather than just the text, in order to understand what Congress wanted to do here. And that also helps us in addition to the text. So she was alone in doing that, and kind of harked back to an older age where the legislative history was used, but that was also notable.
Yeah, I would note here that there is a debate among textualists about to what extent legislative history might still be relevant, and some textualists, like the prominent textualist Court of Appeals Judge Frank Easterbrook, have said legislative history can sometimes be used to illuminate the understanding of the words at the time, because what most textualists say is not necessarily the meaning of those words today, but rather the meaning of the words at the time the law was enacted. And so the legislative history from back in 1977 can help illuminate how the words regulate was understood in the IEEPA at the time that it was enacted.
I want to go back to Justice Gorsuch's concurrence, which I thought that David French very entertainingly on his podcast referred to as the Festivus airing of grievances, because he really took issue with most of his colleagues in their consistency, or in his view, inconsistency in deciding on these separation of powers, presidential powers cases, and wondered if either one of you wanted to dig in a little bit more on his airing of grievances.
Yeah, I think many of his grievances are well justified. You can argue about whether he should have aired them to the extent that he did in this particular case, but they're well justified. With respect to the conservative justices in dissent, who, among other things, argued that major questions can't apply here because it's a foreign affairs case, he rightly points out that they did apply major questions in previous cases, like the loan forgiveness case and the eviction moratorium case related to pandemic policy, even though those executive actions there also had a foreign affairs impact. Of course, it was about the COVID pandemic, which had a massive impact on U.S. foreign policy in the entire world. So I think they're being inconsistent. He also notes that what's crucial is not whether something is foreign affairs power as such, but rather where it's enumerated in the Constitution, and the power to impose tariffs is clearly a congressional power, not an executive power, not even a power that's shared between Congress and the executive. I think he rightly pounds the dissenting justices for their inconsistencies on major questions, and also on non-delegation, which he raises, even though the other justice majority don't raise the constitutional non-delegation doctrine, which says that Congress can't delegate certain authority, even if it does do so explicitly. With the liberal justices, he basically says, well, in the previous major questions cases, like the loan forgiveness and the eviction moratorium, and also Biden's COVID vaccination mandate, they were willing to use sort of vague words to allow sweeping delegations, and here they were not. They were saying, it's not that the plain text alone resolves it. So he says that they too are being inconsistent. There, I think the argument is a little bit weaker, because obviously each of these statutes in the different cases has somewhat different wording. So I actually think that in this case, it's a little bit less ambiguous than it was in some of those previous cases, and therefore this one was easier to resolve without the major questions doctrine than some of those others. Nonetheless, there is some sense in which those three liberal justices are willing to give broader scope to sort of vague language when it's sort of a Democratic president in power. So his charge has some merit, though I think it has less merit than his charge against the other set of justices that he disagrees with.
Yeah, I agree with the principles behind much of that. I think that Gorsuch sees himself and is seen widely in many circles as the most principled justice on the course. Someone who, regardless of where the law goes, he will vote the way he does, predicated on principle. So less outcome oriented, much more oriented on ideology or interpretive methods. And this was just a prime example of that, where he called everyone else on the court, except for the Chief Justice, the majority opinion out, for being unprincipled and deciding differently on the other cases before them. Whether that was appropriate or not, as Ilya said, is very much an open question. But yes, it very much was a Festivus airing of grievances. And just reading the opinion, you could tell that he was certainly having fun.
It's interesting to read all of the opinions because they are very much so in direct dialogue with each other. And so I do suggest everyone read all of the concurring opinions. I do want to turn now to the dissent. And Zach, Justice Kavanaugh, in his dissent, argued that presidents need flexibility to respond to extraordinary foreign threats. Why did the majority conclude that this flexibility could not override Congress's control over tariffs, and why does Justice Kavanaugh disagree with that?
I actually thought this was the most underexplored part of the majority opinion. Ilya may disagree with me here, but I thought it was kind of weak. Not that I necessarily disagree with it, but that they kind of didn't carve it out as much as I thought would be appropriate. The idea from Kavanaugh is that the major questions doctrine does not apply in the foreign policy or foreign affairs realm, because that's where the president's power is essentially at its apex as a matter of Article 2 and presidential and executive power. And so therefore it has no application or no pull here. The majority disregarded that and said, no, it still applies as a matter of constitutional structure, essentially, but also kind of divorced the idea of the tariffs as not necessarily being foreign policy in nature, even though, of course, they have foreign policy implications. So ultimately, the idea was one side being Kavanaugh and the dissent saying, foreign affairs is the president's prerogative. Major questions has no purchase. The other side saying, no, that's not correct. One, it still has purchase, but also we're talking about tariffs here and not necessarily the realm of foreign affairs qua foreign affairs. So there was a deep disagreement there. And as I said, I don't think it was carved out as much as it could have been in the majority opinion. And I think this issue will remain and we will see it again in a different form.
Ilya, do you want to weigh in on that?
Yeah, I think what's weak here is a dissent by Kavanaugh. You can always say the majority could have written certain things better, and I'm not saying they did everything absolutely perfectly by any means. But just as a general principle, there's nothing in the Constitution which divides foreign affairs powers from other powers. Rather, there's some powers that are enumerated in Article 1, which are congressional powers, and some in Article 2, which are executive powers. And obviously, there's also Article 3 about the judiciary. The power to impose tariffs, referred to as duties and imposts, is specifically enumerated in Article 1. There's absolutely nothing in Article 2 which suggests that this is also an executive power. Now, obviously, it does have some implications for foreign affairs, but almost every major use of government power has some foreign affairs impact when we're talking about a nation as powerful as the United States. And here, what we have is a tax that has a massive domestic impact. As I said before, it would have been something like $1.8 trillion over the next 10 years of taxes on Americans. And lots of studies show that overwhelmingly, not just in a legal sense, but in a practical sense, overwhelmingly the incidence of the taxes on Americans. Studies consistently show that over 90% of the money is actually paid by Americans. Foreigners also suffer some damage in the form of lost sales and disrupted supplier relationships and the like. But this actually has at least as much and probably much more domestic effect than it does international effect. And if you want to just say that merely having some kind of foreign affairs impact exempts something from the major questions doctrine, then the practical effect is that almost any major policy would be exempted for it. Or as Chief Justice Roberts put it, there is no major questions exemption to the major questions doctrine. Any major tax policy or regulatory policy or pandemic-oriented policy is going to have some significant foreign affairs impact, but that does not exempt it from major questions, and that does not make it an executive power, especially in a situation where we're talking about a power specifically enumerated in Article 1 of the Constitution. And finally, as the majority does point out, the power to tax was one that the founders were especially careful to reserve to the legislature because they wanted to prevent any one person in the executive or anywhere else from being able to impose it. And they had the experience of the English kings of the 17th century, like Charles I, trying to wield tax power without the proper authorization of Parliament. And this is actually one of the things over which the English Civil War was fought. It led to Charles I losing his head, literally as well as figuratively. And the founders wanted to avoid a similar experience in the US.
Well, Thomas's dissent certainly stands out there because Thomas's dissent, I believe, references the prerogative of the king in finding a hook for allowing things of this nature. So that's we haven't talked about that as much, but it's a very interesting solo dissent, which essentially says that Congress can delegate many of its powers, in fact, almost all of its powers, except for certain due process powers. And this is one that certainly could be delegated. So there's really no issue here.
Yeah. So I think the only issue here is that this is just a really bad dissent by Thomas. I have a lot of respect for Thomas.
Tell us where you stand.
Yeah.
I have a lot of respect for Thomas. When he's good, he's really, really good. But sometimes when he's bad, he's really, really bad. And this is bad Thomas at work in this particular dissent. Essentially, there's just no textual basis for saying that there are certain powers, that just be completely delegated without any limit whatsoever, which in practical terms means they can never be taken back because you would have to have a veto-proof majority to take it back. And that's especially not true for a power to impose sweeping taxes, which is the kind of power that the framers were especially concerned about not letting the executive have unlimited control over. Moreover, the prerogative power of the English kings was one of the things that the founding fathers and the American revolutionaries wanted to reject. The whole point was to not have the kind of near absolute monarchical powers that even in England by the 18th century, by the late 18th century had largely been rejected. Thomas should have read James Madison's report of 1800, where Madison specifically says that we should not assume that powers that exist in some European countries necessarily exist in the American Constitution. Because the whole point of the Constitution is to create a new system of government, one that's going to be different from those that existed in Europe. And this is one area where there's just, no plausible defense for the kind of thing that Thomas advocates here, which may be why not even the other dissenting justices were willing to go along with him on these issues.
It also shows a profound disagreement between the conservatives. We often see the conservatives on the court lumped together as one block. But here you have Thomas, essentially saying that the president has these profound powers, as Ilya laid out. And then you have Gorsuch saying, no, actually, there needs to be a clear delegation. And they are absolutely at ideological disagreement here. And it is a really, really profound one. Again, that may play out in further cases, but also shows that the conservative side of the court is certainly no block.
I appreciate that. I want to talk a little bit about the practical implications of the decision. And the dissent makes note of this, that the U.S. may be required to refund billions of dollars to importers. Ilya, I should say, I know you've written on this, but I think actually you've written on all aspects of this case. So I could say that to any of these questions. Want to get a sense from you, how might that refund process unfold, and could Congress step in to help address the fallout?
So I have written on this, albeit less than on some other aspects of it. I'm actually not on the case anymore because for this refund phase, I don't have the same kind of expertise as I do on separation of powers issues and emergency powers and the like. But the bottom line is this. U.S. importers, including my now former clients, have paid something like $175 billion in what the court has now declared are illegal IEEPA tariffs. And during the course of this litigation, the government repeatedly said that there should be a stay on the injunctions that we won in the trial court because they say you don't need to worry. You can stay the injunction because we'll keep collecting the tariffs. But if we, the government, end up losing, then we will most assuredly pay refunds and with interest. And now they're sort of backtracking on that. And I think it is just obvious, and you don't have to be like a tariff expert to recognize this, that if the government has collected billions of dollars in people's money illegally, then they're required to give it back and they're required to pay interest. And that's what they're going to have to do. There is now actions in the Court of International Trade, which is the trial court here, to seek the refund of the tariffs, both on the part of my former co-counsel Neil Katyal in the Liberty Justice Center, who filed motions to this effect just a day or two ago in the Court of International Trade, and also I think numerous other importers have also filed similar claims. It may be procedurally difficult. It may take some time. That remains to be seen. And sadly, it may be cumbersome and costly for smaller businesses that cannot as easily do this and, and deal with the procedures than it is for some of the bigger businesses, or perhaps for our clients who still have pro bono representation from Neil Katyal and his excellent team, and also from the excellent attorneys at the Liberty Justice Center. But this money is owed and has to be paid back. What can Congress do? There are proposals in Congress to compensate not just the importers, but also perhaps other people who were victimized by the tariffs, which is really most of the population of the United States, because we've all been paying higher prices as a result of this. In principle, I'm very sympathetic to the notion that everybody should be compensated and not just the importers. But I think as a practical matter, it will be very difficult in that it'll be very hard to say, how much money did you and I spend on higher prices caused by the tariffs over the last year? It's going to be very difficult to estimate that. Moreover, even if we could estimate it in some way, then as sadly as a practical matter, we will be in a certain sense compensating ourselves, because any compensation money beyond that which comes from the payments made for the tariffs will come from taxpayers, necessarily all of us. So I don't know if we will be much better off if, in effect, we pay compensation to ourselves. You can try to structure this in some way that the money would go to those most likely to have spent a lot of money on goods that are tariffed in some way, but I think it would be a difficult morass. And I think the real answer to this broader issue of compensating people other than the importers is that the court should not have ruled against us on the stay of the injunction. We actually pointed out at that time that there will be these other harms that go beyond the actual payment of tariffs, but the courts, in their wisdom or lack thereof, ruled against us. My hope is that in future tariff challenges, they will learn from this mistake, and that the next time courts strike down the illegal tariffs, they will not stay their injunctions during the course of the litigation, but rather make them go into effect immediately. Then we will not have this sort of problem again, or at least not in this scale.
Zach, anything you want to weigh in on what Congress might be able to do to help address the fallout from the decision?
I mean, I think at the end of the day, as Kavanaugh said, for better or worse, which was actually Barrett saying it originally during oral argument, was it'll be a mess. As Ilya said, it's going to be especially difficult for smaller businesses. I know there are portals and infrastructure being set up to help them get and go after these refunds, but it's going to become especially complicated if and when the administration pushes back and makes it even more difficult to get these in the first place, which is a live possibility. So it's going to be a laborious, difficult process. As for cost to consumers, I think that is, a very difficult question, and one I don't think is going to be resolved at all. I mean, we'd have to go back and look at our, what we spent last year, itemize, catalog our expenses, and turn. I don't see how that would be possible as a practical matter. Maybe if everyone submitted one large purchase they made that could somehow be traced to, particular tariffs on that product, and even then it would be argued, okay, well, the degree of those tariffs. So that's an incredibly complicated, difficult question. So I think, as the strongest case scenario is that some of these businesses, especially these businesses who claim tariffs cost the most for them, are able through the court process to eventually get refunds back. But the amount of time that will take, it's likely to take a lot of time, and the amount of money that they're actually able to get back in refunds is also a real open question.
while it may turn out to be a mess, it doesn't have to be. At least with respect to the importers who paid tariffs, the government has a record of which importers paid tariffs and how much they paid. In this day and age, if the government was willing, it would be very easy to simply send out all of them checks or perhaps electronic transfers. This would be very simple. So the only reason why that part of it would be a mess is because the government is illegally resisting paying what it owes. If they just were willing to send out the checks or electronic payments, it would be very easy, at least with respect to the actual refunds for actual tariff payments. Zach is certainly right that any kind of refunds for consumers or other indirect harms, that would be much more difficult and maybe in many cases impossible.
Ilya, we also know that the administration is not done with tariffs. Right after the opinion was announced, the administration shared plans to rely on Section 122 of the Trade Act of 1974 for a new tariff. Does the court's insistence in the majority on explicitly clear, limited delegations put statutes like Section 122 at risk of future challenges?
So Section 122 is part of the Trade Act of 1974. And what it says is that the president can impose tariffs of up to 15% for up to 150 days if there is an international balance of payments problem, which results in a serious and ongoing balance of payments deficit for the United States. And there's also a couple other situations where where if there's an international balance of payments problem, it could be used, but the balance of payments deficit is by far the most significant one. And the bottom line on this is that this kind of balance of payments problem or balance of payments deficit simply cannot exist in the type of international monetary system we have now, as opposed to the fixed exchange rate system that existed before 1973, and which in 1974, when Section 122 was enacted, many people thought might be reinstated. So under the fixed exchange rate system that existed pre-1973, the United States was committed to exchanging dollars for foreign countries' currencies at fixed rates. And also, it was committed to exchanging dollars for gold at a fixed rate. I think it was $35 per ounce. So in that fixed exchange rate system, known as the Bretton Woods system, we had a situation where potentially the US government could run low on dollar reserves because maybe many more people were trying to exchange foreign currencies for dollars at the fixed exchange rate than vice versa. And also, as actually happened in the early 1970s, US gold reserves could run low if a lot of people started trying to exchange dollars for gold. We actually did start running low on the stocks of gold in Fort Knox or wherever the US government stored its gold at that time. And that was sort of a crisis that President Nixon tried to deal with in 1971. Under flexible exchange rates, which we have had since 1973, this simply cannot happen. The United States is no longer committed to exchanging dollars for gold. So we don't have a balance of payments problem with our gold reserves. And if the demand for dollars goes up, then under a flexible exchange rate system, simply the dollar itself goes up in value and it balances out. So this simply cannot happen. Don't take my word for it. Take that of numerous international trade and monetary economists who have said similar things in recent days, and take that of Milton Friedman, probably the greatest monetary economist ever, who in the 1960s specifically wrote that one of the advantages of flexible exchange rates is that you can't have these balance of payments deficit problems. They simply cannot exist. So basically, Section 122 can only apply in a world which does not exist currently and is unlikely to exist anytime soon. And in addition, if there is ambiguity about the meaning of Section 122, then I argue in my Boston Globe article that the major questions doctrine would apply because 15% tariffs on or 10% tariffs is actually not entirely clear whether Trump is imposing 10 or 15%, but either would be, if imposed on the entire world, either would be an obvious major question. And moreover, if the president can play fast and loose with the language of 122, then he can probably easily just reimpose the tariffs after the 150-day period. He could just say, well, 1 minute after the first 150 days runs out, he can just say, well, we have another slightly different balance of payments deficit or something like that. And if he can play fast and loose with the language, this would be a major questions issue, very obviously. Even for one 150-day period, it may be a major question because it would be tens of billions of dollars in tariffs paid. And I would also argue that non-delegation applies here as well. So I think these tariffs are also illegal, and there is likely to be litigation over them sooner rather than later.
And the administration is obviously going to front its argument when it comes to it with the idea that, listen, you told us in terms of IEEPA, the problem was that tariffs were not mentioned. It said regulate importation. But here, tariffs are explicitly mentioned. And now you're telling us even when tariffs are mentioned, we can't use the president's power to impose them in this particular way. Now, for all the detailed reasons Ilya gave, will say, yes, even under the statute as written, you cannot do that. But the administration is going to create, I think, a more atmospheric argument in some sense, saying that, okay, we're allowed statutorily to levy tariffs. And now essentially what courts are doing is coming in and micromanaging what we can and cannot do. And at some point, it needs to be enough. And the president should be able to have the ability to do this.
Yeah, I guess the obvious answer is that it was also crucial for all 6 majority justices that the president not have a virtually unlimited power to impose tariffs. And that is pretty much what he's claiming again. And the mere fact that the word tariff is mentioned in the statute, that does not mean that there's an unlimited power to impose them. It just means you can impose them in certain particular circumstances. And in this case, it is circumstances that not only do not exist, but actually cannot exist unless and until we have a completely different monetary system.
I want to talk a little bit about the broader issue of emergency powers and judicial deference, which we started to get to a little bit earlier in our conversation. The court doesn't directly address how much deference to give to presidential invocations of sweeping emergency authority. Why do you think the court left that question unresolved, and how might it confront that issue in future cases?
I mean, it's probably because it's an incredibly difficult question, and they wanted to keep it here to the text and the facts in play. Now, there's a famous, the steel seizure case. Justice Jackson, in his opinion in that case, a concurrence, he wrote that the president's powers are essentially at different levels or apex in certain areas and weaker in others. So kind of courts sometimes, but not always, weigh this balance of power when it comes to the president. But where those powers, are at their greatest and at their weakest is such a broad, sweeping, and important question that it is one that the court obviously wanted to limit in this particular case and kind of keep it to the statutory text, keep it to the major questions doctrine where it could, and leave those questions for a later date if it has to reach them at all. And it very well may, but this was not the time the court felt to do that. Justice Thomas in dissent did not think so much. Indeed,
Right.
his dissent was all about the powers of the president, and so was the principal dissent, Justice Kavanaugh's, to a certain extent. But the majority opinion wanted to keep that very limited, and that's also reflected in how short the opinion itself was, especially compared to Gorsuch's concurrence and the dissent.
Yeah. So the issue of the scope of emergency powers and judicial deference there is something I've written about a lot, and it was one of the arguments we made in this case because under IEEPA, even if you assume that IEEPA does allow the use of tariffs, IEEPA also says they can only be used in response to an emergency, which qualifies as an unusual and extraordinary threat to America's economy, national security, or foreign policy. And the rationale for most of the tariffs was trade deficits, which, as we argued, are not unusual or extraordinary. They happen all the time, and they're not even a threat because most economists will tell you that trade deficits are not actually harmful. They're not a problem. The court understandably chose not to address that because they essentially said this statute doesn't allow you to impose tariffs no matter what, whether there's an emergency or an unusual and extraordinary threat or not. But this kind of issue is likely to come up in future cases. It is at the heart of the Alien Enemies Enemies Act litigation going on right now. The Own Enemies Act is a power that, for the most part, can only be invoked when there is, quote, a declared war or an invasion of the United States. And so there's an issue of what counts as an invasion and how much deference should be given there. The administration somewhat absurdly claims that illegal migration and drug trafficking qualify as an invasion. I think that's wrong. And you can read my article, Immigration is Not Invasion, which is currently under submission to our reviews, my other work on this topic. I also have an article in the Dispatch from last year entitled Not Everything is an Emergency, where I explain at some length where when courts review invocations of extraordinary emergency powers, they should carefully consider whether there really is the kind of emergency that justifies the use of those powers, and they should not defer merely to the president saying that that emergency exists, because if they do defer in that way, then those extraordinary emergency powers become blank checks that the president can use anytime he wants, which in many cases is a grave threat to civil liberties, to our economy, and to the rule of law. To take just one example, in the event of invasion, the Constitution says that you can suspend the writ of habeas corpus, which in plain English means you can detain people, including U.S. citizens, without any due process. And that is not the kind of power that the federal government should be able to invoke anytime it wants, which, by the way, it could if invasion includes illegal migration and drug smuggling, because those things happen virtually all the time, or at least all the time since we've had the war on drugs and immigration restrictions. But obviously, this issue of judicial review of emergency powers, it is ongoing. And while the court didn't have to address it in this case, it may have to address it in future cases, including possibly in the Section 122 litigation that we mentioned earlier, because while there the word emergency or threat is not used, obviously, clearly, this is a statute that's only supposed to be used in the extraordinary circumstance where there is an international balance of payments problem and a balance of payments deficit and the like. And if the president can just say, well, if I say this thing exists and it exists, then that too would be a power that he can use anytime he wants. And he would have the kind of sweeping tariff authority that the court rightly denied him in the IEEPA case.
I mean, presidents invoking emergency powers to, issue sweeping and, ultimately huge restraints on all sorts of aspects of society is something we've seen throughout American history. And it has a very mixed record before the court and elsewhere. It's from the very beginning of our country, and we've seen it in absolutely terrible times. One that, of course, comes to mind is the Japanese internment case, Korematsu, and the court essentially allowing that to continue. But of course, there were also emergency powers invoked by Lincoln during the Civil War, including Ilya mentioned the suspension of the writ of habeas corpus, which Lincoln put into place. So it's a very mixed and complicated legacy. But as over time, more and more power has gone to the executive branch, and especially the presidency, it becomes even more important and crucial to get a sense of what powers are ultimately conferred on the president by the Constitution and how the court is going to treat that.
This is a perfect segue to my last question for both of you, which is whether or not this case is a defining moment for the separation of powers between Congress and the president. And Zach, let's start with you.
I think it is. I know you mentioned David French, I believe on the podcast Advisory Opinion. He said this was because it put curbs on presidential power and defined the separation of powers to a certain extent. This was the most important case of, this century so far. I don't know if I'd go that far. I still personally think if we count it, that Bush versus Gore may have been the most important one, especially in what followed. But ultimately, there is no doubt that this was an incredibly important opinion, not only because it put curbs on this president's powers and made clear that this court was willing and able to do so, but also it showed a divide among the conservatives on the court and just what powers should be curbed and in what ways. And that's going to play out in some very significant ways moving forward. And as we see more of these cases come up, whether in immigration, healthcare laws, all sorts of things are going to percolate. So this will certainly act as an important precedent in curbing presidential power and using the major questions doctrine. But there's still a lot of issues that remain to be resolved and a lot of lingering questions.
Absolutely. Ilya, big case?
So I think it's difficult to have a definitive judgment on how big it is when we don't yet have anything in the way of historical perspective.
Well,
and
we've
also,
had a whole week, Ilya, and a lot of podcasts.
Yeah, a whole week.
Yeah.
Not even, but that's more than enough.
And this is already my third or fourth podcast about this case. So maybe that's all we need. And obviously, I was going to say that, because I was one of the lawyers on the case and the case originated in a blog post that I wrote, I'm not the most impartial and objective observer of the importance of the case. Nonetheless, I think it is significant, both for the reasons that Zach mentioned and also because even just in the area of trade policy, I think it is very significant that all 6 majority justices, albeit in somewhat different ways, said that you could not have a virtually unlimited delegation of tariff authority to the president. And that is going to be very important because obviously trade policy is itself a very important area of federal power. So even if the significance of this case is limited just to international trade and tariffs, that's pretty important in and of itself.
Zach, Ilya, thank you both for this thoughtful and illuminating conversation. I'm so grateful for your time and the care you both bring to helping others understand more about the court and the Constitution. Thanks again for joining us.
Thank you.
Thank you so much.
This episode was produced and mixed by Bill Pollack. Research was provided by Anna Salvatore, Trey Sullivan, and Tristan Worsham. In celebration of America's semi-quincentennial, we launched the wonderful America at 250 Civic Toolkit, including a new interactive Declaration of Independence. The toolkit convenes America's greatest historians and legal scholars to write about the big ideas of the Declaration and Constitution. I hope you'll check it out at constitutioncenter.org. And while you're there, sign up for our newsletter to get our full lineup of exciting programs throughout 2026. Please recommend our show to your friends, colleagues, or anyone anywhere who's eager for a weekly dose of constitutional illumination, exploration, and debate. And always remember that the National Constitution Center is a private, nonpartisan nonprofit, and we rely on your generosity, passion, and engagement for all of our programming. Please consider donating at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Julie Silverbrook.